Morning, everyone. Mr. Knapp, would you please call the roll?
Yes, sir. Thank you, Mr. Chair. Good morning, Commissioners. Barcelona,
Here.
Braun,
Here.
Brazil,
Here.
Cooper,
Here.
Doring,
Here.
Yule,
Here.
Gordon,
Here.
Johnson,
Here.
Long,
Here.
Moon,
Here.
Nieto,
Here.
Rodriguez, Terrio,
Here.
Woolry.
Here.
13 members present.
Thank you. Thank you very much. Good morning, everyone. I'm Jeff Long, the Chair of the Post Commission. The date is November 17th, 2024. It is 8:05. The meeting is called to order. We are on the record. First, one small item of business. We'd like to welcome our newest commissioner appointed this week or last week by Governor Newsom is Officer Jake Johnson, President of the California Association of Highway Patrolmen. I'll leave that to others to discuss. Welcome, Commissioner Johnson. If you don't mind, would you like to say a few words about your appointment and what you hope to bring to post?
Just talk.
Just talk. Oh, it picks it up. Thank you. Good morning, everybody. Good morning, people behind me. Appreciate the opportunity to be a part of this. Yes, I represent the California Association of Highway Patrolmen, which is the largest state police association in the nation. But it's not what I'm most proud of. I'm most proud of being a couple decades plus rank and file officer of the CHP. I'm proud that I've been assigned to patrol the entire time. And so I look forward to being part of this, the Post Commission. It is a very difficult and important job that the people do here. And I look forward to working with fellow commissioners, post, community members, elected officials, stakeholders, and all those people trying to create a better environment, an enhanced environment for law enforcement officers and the transparency that the public enjoys. And so I followed this commission since it was enacted, and I appreciate the things that this group has done. I appreciate the transparency that you get from this process. And so I look forward to working with everybody in the room. Thank you.
Thank you, Commissioner. I would now like to introduce Peace Officer Standards Accountability Advisory Board Counsel, Christopher Beatty, Post Chief Counsel William Toby Darden, who is not at the dais at the moment, and Post Executive Director Manny Alvarez. This is the time set aside for members of the public to comment on items on the commission agenda or under the commission's jurisdiction. Public comment on specific peace officer revocation cases scheduled to be heard today will be taken at the time that those cases are brought up. Pursuant to commission policy, the chair will manage public comment in deference to the commission's workload. Up to 15 minutes is allotted at the beginning of each commission meeting for public comment. Please be advised the commission cannot take action on items not on the agenda. Members of the public who wish to speak are asked to limit their remarks to no more than 5 minutes. If numerous people wish to speak on the same topic, I may intervene and ask that you limit your remarks to no more than 1 minute. Also pursuant to commission policy, the chair may conclude public comment if multiple speakers are voicing repetitive statements and the 15-minute public comment period has expired. Before we open public comment, please note that if you have a specific complaint about an officer who is not on today's agenda, you should file a complaint with Post or with the officer's employing agency. Staff will assist you in this regard during the next break. And I would like to remind anyone making comments to not discuss pending complaints or pending disciplinary actions that may later come before the board or the commission for a recommendation. If the board and commission take action on your complaint, you will have an opportunity to comment at that time. This is necessary to comply with the law and to avoid compromising the commission's or the board's charge. Finally, please remember this meeting is being transcribed, so speak slowly and clearly so your comments can be accurately transcribed. Do we have anyone here who would like to address the commission? All read for naught. We are meeting today for case review of recommendations made by the Peace Officer Standards Accountability Advisory Board. We have 4 cases today. We will review the facts and evidence presented by the Peace Officer Standards Accountability Division and the recommendation of the Peace Officer Standards Accountability Advisory Board. This is not an evidentiary hearing. The rules of evidence do not apply. Evidence is not formally admitted into the record. There's no need to make objections, and objections will not be ruled upon. Under the Penal Code and applicable state regulations, this hearing would determine if the matter should proceed to a full evidentiary hearing before an administrative law judge to determine whether the allegations are true and justify discipline. At this stage, the commission must only consider the facts that the division, after investigation, believes can be proven at a later evidentiary hearing. For that reason, today, the commission will entertain arguments as to whether or not those facts, as presented by the division, demonstrate a high probability that serious misconduct, as defined by Penal Code Section 13510.8 and Reg 1205, occurred. An affirmative finding results in the matter moving forward. No actions by the commission prior to a full evidentiary hearing amount to a final determination that an officer engaged in serious misconduct or that revocation or suspension is mandated. One brief note before we begin the cases, I would like our counsel, Christopher Beatty, to address what is essentially some late submissions.
Okay, I wasn't anticipating that, but I'm under the understanding, without having the benefit of the review of the submissions, that we have some submissions from the respective officers regarding the potential decertification that's in front of the commission. And so I guess I would just say this. The materials have been submitted. There's also an opportunity for public comment, but there's a lot of work to be done today. So we're going to take the materials for the value that it has, if any, and we can address that quality. But just keeping in mind that public comment should only be considered by the commission if it is appropriate. And what I mean by that is really you're looking at the investigation report provided to you and trying to figure out whether that report has clear and convincing evidence to maintain the recommendation by the board. And so that's the basis. If there's public comment or any content within these written submissions that's external to that focus, that's really beyond the scope of the review that the commission has here today. And hopefully that's responsive.
That was responsive. Thank you very much. I now will call upon law enforcement consultant David Paletta, Professional Conduct Bureau, Post Southern Bureau, and Bryant Henley, Post Legal Affairs Bureau, to report on post case 2303451, James Matuku, who at the time of the events at issue in this case was employed by the Riverside Police Department. Gentlemen.
Morning, Chair Long and Commissioners. My name is Dave Paletta. I'm a law enforcement consultant assigned to the Southern Professional Conduct Bureau in the Peace Officer Standards Accountability Division. Joining me today to my right is Brian Henley, an attorney with the Legal Affairs Bureau. I'm here with respect to post case number 2303451 versus Sergeant Matuku, formerly of the Riverside Police Department. In this case, the division found reasonable grounds to believe that Sergeant Matuku engaged in serious misconduct in violation of Penal Code Section 13510.8, subsection A1, alleging that Sergeant Matuku was dishonest when he repeatedly lied during two separate internal affairs interrogations into allegations of misconduct. This occurred on January 19th, 2023, and again on February 21st, 2023. In the division's investigative summary and findings, it recommended revocation of Sergeant Matuku's post-certification. In accordance with the requirements of Senate Bill 2 and as required by Penal Code Section 1310.85A4, this matter was heard by the Peace Officer Standards Accountability Advisory Board on October 17th, 2024. Following the conclusion of that hearing, the board voted to recommend the revocation of Sergeant Matuku's certification. The division asks that you adopt that recommendation today. As required by Penal Code 13510.85, subsection A5, The record that proceeding is before you, which includes the agenda, attachments from that meeting, a transcript of relevant portions of the hearing, and the recommendation of the board. If the matter was heard in closed session by the board, Commission counsel will be able to advise you with respect to those proceedings. The law requires your review to be of that record before the board, which is before you and which you've had the opportunity to review. To assist you in your review of that record, I will take you through the case as it presented there. As the record shows, I presented the case before the board substantially as follows. Sergeant Matuku was a sergeant with the Riverside Police Department. He is married to a Riverside police officer who are referred to as Officer Number 1. On September 16th, 2022, a patrol officer who are referred to as the complainant worked on Officer 1's team and filed an internal affairs complaint against her alleging that she failed to properly handle the call for service. 16 days later, on October 1st, 2022, the complainant reported encountering Sergeant Matuku at the police station. The complainant stated he walked by the complainant and greeted him, The complainant stated as he walked by, the complainant greeted Sergeant Matuku. In response, Sergeant Matuku said, "You'll see, you'll see." On October 3rd, 2022, the complainant came to work and found paper flyers with a picture of a large rat crossed out and the words "Rat Busters" written under that image. One of the flyers was placed in the complainant's mailbox, while the others were distributed in various locations within the men's locker room. One of these locker room flyers was housed in a vinyl casing and affixed to a bank of lockers. On October 4th, 2022, the Riverside Police Department initiated an internal affairs investigation, and Sergeant Matuku was the accused employee. Investigators reviewed surveillance footage and IT data from Sergeant Matuku's police station on October 1st, 2022. They discovered at 4:05 p.m., Sergeant Matuku is seen walking from the parking lot towards the entrance of the station. At 4:17, the Rat Buster file was downloaded and saved and named with 2 capital letters, which were the complainant's initials, on a computer located in a report writing room. At 4:36 p.m., that file was printed in that same room. The internal affairs investigation into Sergeant Matuku led to 2 separate interrogations where Sergeant Matuku repeatedly denied that he created, printed, saw, touched, or placed the flyers. He also denied that his fingerprints would be found on any of the flyers. Subsequently, fingerprint examiners confirmed that both Sergeant Matuku's left and right thumbprints were located on the flyer that was housed inside the vinyl container. Sergeant Matuku was interviewed a second time by investigators, and during which he repeatedly denied any involvement with the flyers, stating no fewer than 10 times he had nothing to do with them. This investigation revealed that Sergeant Matuku had a motive to place the flyers, and both circumstantial and direct evidence support that he was responsible for them. There is clear and convincing evidence that Sergeant Matuku repeatedly lied to internal affairs investigators. The motivation for Sergeant Matuku's lie was to cover up his actions at work in which Sergeant Matuku threatened another employee. Sergeant Matuku was terminated from the Riverside Police Department on October 20th, 2023 for dishonesty related to the Riverside Police Department's investigation into his misconduct. On May 13th, 2024, Post interviewed Sergeant Matuku, during which he maintained his denials of any involvement in the creation or distribution of the flyers. Based on the facts of this case, as described here and in the investigative summary and findings, there is clear and convincing evidence that Sergeant Matuku committed acts of dishonesty. Therefore, the recommendation is that Sergeant Matuku's peace officer certification be revoked. Following my presentation to the board, and as documented in the transcripts before you, Sergeant Matuku made public comments. I understand that Sergeant Matuku, along with his representative, submitted written comments to the commission and will be making further comments as part of this proceeding. Members of the board raised questions relating to the number of topics which prompted discussion between the parties present. The topics included whether Sergeant Matuku presented his theories to Riverside Police Department management, whether a card reader audit was conducted, and whether surveillance footage showed Sergeant Matuku entering or exiting the station. A discussion regarding the fingerprint analysis of the flyer, including the flyer enclosed in a vinyl casing. And lastly, whether Sergeant Matuku ever filed an equal employment opportunity complaint or appealed the Riverside Police Department's decision to terminate him following his Skelly hearing. Members of the community addressed the board and provided general public comments. These comments are contained in the transcript of the hearing, which are provided to the commission. The board went into closed session. When the board returned into open session, it voted to recommend revocation of Sergeant Matuku's certification. 4 board members were in favor and 3 voted against the motion to recommend revocation. If the commission has any questions, Bryant and I would be happy to answer them at this time. Thank you.
Questions or comments? Commissioner Barcelona.
This document that just got put on the desk here from Brad Gage Law, he's stating in here that that there were no conclusive prints. Did you see that? Can you give me a rundown on that?
Commissioner Barcelona, this is Brian Henley. I'm on behalf of the Peace Officer Standards Accountability Division. I'll be happy to address those comments if you wish at this time, Commission Member Barcelona. I do know that Mr. Gage is planning to give a presentation himself.
Oh, yeah.
And whether you would like for me to address those written remarks now or later, I respectfully defer to you.
Well, why don't you just do it now since we're here?
Very good.
I mean, just as far as the prints go.
Yes, Commissioner. So I think the first point I want to emphasize is, as Mr. Chair has emphasized and your counsel, Mr. Beatty, has mentioned, there are a number of things in the document you just referenced, which is before the commission, which go beyond the scope of what these proceedings are designed to focus on. And not to belabor or too much repeat what you've already heard, but today's proceedings, many of the commission members, maybe some of the newer ones, have not heard this before, but they're, as SB2 is a new process, we talked about the new process. There are really 3 phases to the SB2 serious misconduct process. Phase 1 is a presentation to the board, which we've had here in Mr. Matuku's case, where the board considers whether there is sufficient evidence by a clear and convincing evidence standard from the investigative summary and findings to move the case forward to the commission, which they have done. The commission then today reviews the investigative summary and findings document that Mr. Paletta has prepared. It reviews the board record that was before the board, and based on those records alone, the investigative summary and findings and the record before the board, whether that information is sufficient to show by clear and convincing evidence that the case should go to phase 3. Phase 3 being a full evidentiary hearing before an Administrative Procedure Act administrative law judge. So I want to start with the framework here to say, back to your question, Commissioner Barcelona, the document attempts to introduce here today a number of pieces of evidence that are not part of the investigative summary and findings. They are not part of the record before the board. What that document does is it goes beyond what the regulations provide. The specific regulation is Title 11, California Code of Regulations 1209, which states that no new information, no new evidence may be introduced at this phase of the proceedings.
No, when I went through the evidence on this when I logged in, I saw where the sheriff's department had confirmed the prints were on it, and he's saying they weren't. I just was curious how he arrived at that, if you know. I mean, that's all I'm asking.
Understood. Thank you, Commissioner Member Barcelona. He will make, Mr. Matuku's counsel will make his advocacy remarks. I can tell you that from our position, there is no dispute that Mr. Matuku's fingerprints were found indeed on one.
I saw it on the evidence. I saw the certification by the print analyst and all that. I just was curious. So if they're going to be here, then I can ask that as well. Thank you
Thank you.
so much.
Thanks, sir.
Commissioner Brazil? You had that look.
No, sir, I'm good.
Any other questions or comments from the commission? All right, why don't we hear from Mr. Matuku's attorney at this point?
Good morning. I am Brad Gage of Brad Gage Law. I represent Sergeant Matuku. And I'm here to make public comments related to whether the record in its entirety supports the peace officer standards conclusion of serious misconduct was established by clear and convincing evidence. And I will explain why I believe it does not. And then I will also address the question of the board regarding my comments regarding the fingerprints. By way of background, Sergeant Matuku was involved in an investigation against the complaining officer of creating a hostile work environment. Thereafter, that complaining officer claimed that Sergeant Matuku put up a rat buster poster or flyer in different locations. And I am addressing the decisions of the Post Accountability Division, finding that Sergeant Matuku lied and provided misleading statements. We heard from the advocate that there were 10 different times that Sergeant Matuku gave a misleading statement, but they were all the same statement, and that was that he did not put up any of the flyers. By way of background, there were at least 4 different rat flyers that were found in the department. There were no fingerprints of Sergeant Matuku found on at least 3 of those flyers at all. There were, however, fingerprints of other people found on those flyers, which apparently were never examined except for the complaining officer, and they did find that his fingerprints were on some of those flyers. That's important because there was also testimony in the internal affairs investigation that Sergeant Matuku had heard that the person that put up these flyers was the complaining officer, and that it was put up in retaliation for Sergeant Matuku testifying against that officer in a prior investigation. So 3 different fingerprint experts reviewed the flyers. 2 of the experts said there were no prints on any of the flyers that they examined that belonged to Sergeant Matuku. There were, however, multiple prints that belonged to the complaining officer, and as we understand it, 10 other people. Those 10 other people's names were not checked. We don't know who they are, but we do know that they had to be members of the Riverside Police Department because this was a secure facility that you had to have a badge in order to enter. One of the 3 experts who said in the document, and in my letter, I did attach the exhibits themselves. I would request that the commission be provided with those exhibits. They were not provided to you, I understand, but I believe that those exhibits show exculpatory evidence that was withheld during the initial phase, that those documents show that Sergeant Matuku did not lie and did not give misleading statements, and that as a matter of due process, they should be examined now even before it gets moved on to a full administrative law judge. You will see in those documents that the one investigator who said in one place that he found, or she found, that there were fingerprints also had indicated in the document at page 1 of it that there were no such matches. And that is what I put into my document. And it says specifically in Exhibit 4 at page 1, quote, Layton's were searched but not identified through the following: AFIS, local, state, FBI, and then continuing, a known comparison was made and there is no match to Officer Matuku James. The report is dated on January 20th, 2023. At page 2 of that report, it indicates that there were fingerprints of the complaining officer. Then at page 3 of that report, which is inconsistent with page 1, it says that 2 prints belonging to Sergeant Matuku, as well as multiple prints for the complaining officer and several other officers' prints were found on the flyers. And so that explains why I've indicated that there is this discrepancy, which whether there was any print of Sergeant Matuku on any of the flyers. There were 4 different flyers, and there clearly were no prints of him at all on any of the other 3 flyers. So when you're looking at a clear and convincing evidence standard of whether or not to have something move forward, these inconsistencies and the fact that 3 flyers do not have fingerprints of Sergeant Matuku, but do have fingerprints of either the complaining officer or others, that indicates that certainly someone was putting those up. We believe it was the complaining officer himself because he had the motive to do it, because he did not like the fact that Sergeant Matuku, who is African American, was married to Officer 1, who is Caucasian, and that the complaining officer had a complaint against Sergeant Matuku's wife, who was lactating at the time, and he was described as old school and didn't like those kinds of things happening by police officers who in the past had been traditionally male and white. And that's part of the motive of the complaining officer to frame Sergeant Matuku. There was evidence that the attorney presented today showing that Officer Matuku was seen in the parking lot. But there was not evidence that Sergeant Matuku entered the building. And that, of course, is vital in determining whether there is clear and convincing evidence to demonstrate that Sergeant Matuku lied when he said he did not put up those flyers. Because if he never entered the building, he could not have been the one to put them up. That video initially in the internal affairs report by the officer claimed that he was seen inside the building, but that does not match with our understanding of what happened. And again, the attorney presenting the evidence a moment ago indicated it just showed him in the parking lot. It did not show him inside of the building. When there are multiple other officers' fingerprints that are found on the flyer, that is significant also on whether or not there's clear and convincing evidence to move this case forward to the next phase, because none of those officers were identified. None of them were questioned. Some or all of them could have had stronger motives to put those posters up as to the complaining officer, but we don't know because of the lack of information. That's exculpatory evidence that has been withheld from Sergeant Matuku, putting him in a very difficult situation. It frames him, but it does not demonstrate clear and convincing evidence. Also, there are GPS logs that would show what other units were present, showing who was in the building. However, as we understand, those GPS logs showing who else was there were not obtained. Since we don't know who the other officers were in the substation, they were not interrogated during the internal affairs investigation. They could also have motives. Those individuals that were there easily could have had fingerprints matching those fingerprints that were found on the wrap poster or flyer, but that were never checked. There are also badge reports that would show who was in the station at the time, coming and going. Those badge reports were not obtained. The officers were not interviewed. All those suspects could easily be the ones who actually put up the poster. And that again affects the high, clear and convincing evidence standard of whether or not to move this case forward. Also, there's no doubt that the complaining officer was working at the substation when those flyers were printed and posted. His fingerprints were found on the posters. It's a perfect way for him to have framed Sergeant Matuku, but that evidence was ignored. When Sergeant Matuku was initially interviewed by the Internal Affairs Sergeant, he was told he was not a suspect, that he did not need representation. He was not even told of the nature of the charges against him. That again is an unfair process. Then you have the exaggeration by Officer F claiming that a cartoon with a rat on it is a threat to his life. In an attempt to support that fallacy, the complaining officer claimed that Sergeant Matuku made a gesture with his hand of pointing a finger like if it was a gun towards Officer F. Yet, as I understand it, none of the witnesses interviewed supported that such a gesture ever occurred, and that allegation was not sustained by the department. Thank you.
Thank you. Comments or questions of Mr. Gage from anyone on the commission? Is anyone else here to represent Mr. Matuku? Officer Matuku, anyone, is there anyone from the public who would like to address the case at this point?
And Mr. Chair, if I may, I'd just
Yes.
like to respond briefly to Mr. Gage's remarks. And
Yes, sir.
I don't want to belabor this. I know the commission is well aware of the regulations and the procedure. I do want to emphasize that many of the statements that you just heard today are beyond what the investigative summary and findings provides in terms of the evidence. They go beyond what the record before the board was. There are references to other documents that are not part of those materials. We here at Post received those documents from Mr. Gage on November 18th. There's never been an opportunity to authenticate those, to have the fingerprint witnesses or experts corroborate or disconfirm some of the statements that you've heard from Mr. Gage. And some of these types of issues are precisely why it's important to remember the phase we are in. This is the second phase in the process. It is not the full evidentiary adjudicatory hearing. There is an opportunity for an administrative law judge to receive evidence, to hear whether some of the statements that were made by Mr. Gage have any factual value or whether they cannot be proven, just as the division will have to prove what is in its investigative summary and findings. The proof of all of these pieces of evidence, that hasn't occurred yet. And today we're asking the commission just to consider whether the investigative summary and findings as presented to you, does it, along with the record before the board, show if it is proven to be true, and that's a big question, if those things are proven to be true, does that demonstrate by clear and convincing evidence that Mr. Matuku was dishonest? We respectfully submit to you that the evidence is very strong and clear. It does meet that high probability or clear and convincing evidence standard. And we do believe we can prove to an administrative law judge that in fact, Mr. Matuku was dishonest, that he was indeed the individual who posted the flyers. And we are prepared to prove that before an administrative law judge. The question before you today is whether you agree that there is sufficient evidence to move this case to the ALJ. I'd be happy to answer questions of the commission members about the evidentiary issues. But again, it really boils down to the nub of Code of Regulations 1209, which says the focus today is on the investigative summary and findings, what it provides, and what the record before the board was. Many of the statements that were raised today go beyond that, and we're not at that phase of the process. And I'll stop there.
Commissioner Braun.
Commissioner Braun.
I do have a question for Mr. Gage. What is Mr. Matuku's employment status now? Is he appealing the decision with Riverside, or is that settled?
We have the appeal equivalency through a lawsuit. We have filed first of all, he did a Skelly, but after that, you have to make an election under the case of Schifando, SCHIFANDO, I think it's versus City of Los Angeles. You can either proceed through an administrative challenge or you can proceed through a lawsuit, but you can't do both. So we have a lawsuit that is currently being pursued in connection with claims of discrimination, harassment, and retaliation. The basis of those is in part on the fact that Sergeant Matuku was in an interracial marriage, which the complaining officer did not like, and that the complaining officer is made the allegations against Sergeant Matuku because of the fact that Sergeant Matuku was called in as a witness against him in connection with the allegations that the complaining officer had created a hostile work environment. And we also have a hostile work environment claim for both Sergeant Matuku and his wife as part of that lawsuit.
Thank you. Is his employment settled? Is this a suit for damages or to regain his employment?
The way we have to proceed is as a suit for damages. What I have had happen in other cases when I've represented police officers over the past 39 years is frequently as part of a settlement of a civil case, you can get reinstatement.
Quick question, Mr. Henley or Mr. Paletta. See, the officer was terminated and he withdrew his Skelly, if I recall.
He was terminated, yes. He actually had a Skelly and presented facts. I don't know what those facts were. And then he filed an appeal for the Skelly and then withdrew that several weeks later.
Commissioner Woolery.
Thank you, Chair. Thank you, Mr. Henley, for the clarification. I think I'm one of the newer commissioners, so it's all helpful. Just a sort of a foundational question. The clear and convincing evidence standard, is that universal at every stage of this process?
Thank you for the question, Commissioner Member Woolery. And by every stage of the process, if you're referring to the SB2 process, meaning before the board and now before you, the commission and the administrative law judge, if the recommendation is for revocation of a license, it is consistently that standard, clear and convincing evidence at every step of that process. If, however, you're referring to proceedings before the Riverside Police Department to determine whether or not to terminate Mr. Matuku, those standards are generally by a preponderance of the evidence, meaning more likely than not. So it's a different standard that the Riverside Police Department considers when terminating an officer from the standard that must be met before you, before the board, and also before the administrative law judge. I hope that answers your question.
Does it exactly? You answered my question. So there's two different standards, right? And then how does clear and convincing, how does that compare with beyond a reasonable doubt?
Thank you for the question, Commission Member Woolery. So in the way the threshold works, and some of the commission members have had some of this training, and it's also been a long time, but I'll kind of, so forgive me for speaking to things that we've talked about with other members of the body, but at a high level, as we just referenced, there's the preponderance of the evidence standard. It's generally colloquially understood as more likely than not. Jury instructions generally say it's more likely than not that the facts as alleged are true. The clear and convincing evidence standard in jury instructions, a common talismanic language, the common understanding is there a high probability that the allegations have been proven and are true? Is it highly probable that the allegations are true? And then beyond a reasonable doubt, as we know, it's the highest standard within the American system of justice. It is reserved for most of the most critical circumstances, such as life and liberty. So when you have a criminal trial, you have an individual who is either going to be put away in prison or perhaps put to the death penalty. Under those types of circumstances, it's an even higher threshold, that threshold being beyond a reasonable doubt. And that standard, as you might imagine, is considerably higher than a high probability. It's not enough to prove that it's highly probable that an individual committed those acts. You must go to a point at which there is no reasonable person who could doubt the guilt of the individual. That's in essence the beyond a reasonable doubt standard. So they are three increasingly higher standards to meet. We are under the clear and convincing evidence standard, meaning the question before this commission is it highly probable that Mr. Matuku, if we can prove the information that's within the investigative summary and findings of Mr. Paletta, is it highly probable that Mr. Matuku engaged in dishonesty? Is that responsive to your question, Commission Member Woolery?
Yes, sir. Thank you very much.
Follow-up questions of Mr. Gage or Mr. Henley or Mr. Paletta?
My only comment on the preponderance and the different standards is in a civil case, we think of a preponderance as just slightly more than 50%. Clear and convincing evidence is a much higher standard. It's the highest standard of proof that we have on the civil side. Only in criminal cases is there a burden higher than clear and convincing.
Thank you, Mr. Gage.
Commissioner Nieto, I do have a question on the video where he's pulling into the parking lot, and it states in the summary that you saw him get out of the car and start walking towards the station. Is that the only place you could walk to?
Yeah, unfortunately, because of the camera angles in which the cameras provide for the station, they don't actually show the door of the station. They show you walking up to an area, and then unfortunately the angle doesn't carry it, but there's no other place to go but to the station. But we don't physically see him walking in, correct?
Questions? What is the will of the commission? A motion is always in order, or we may adjourn into closed sessions. Question from.
Excuse me, Chair.
Oh, excuse me. Is the officer here to speak? Is that?
Yes, sir. Yes, sir. Hello, commissioners and chair. I appreciate you guys for your time. I just wanted to clarify that last question. It is incorrect that the station is the only place you could walk to from the trajectory I walked. I would actually, my vehicle, my personal vehicle, would have been the direction I was walking into, parked in a parking lot in front of the station. And again, this is a time where I was coming into the station at the end of my shift, and my car, I downed my cruiser, and I would have been walking towards my car. But the station is not the only place that somebody could have walked to from my trajectory. So to provide that clarification and answer any questions.
Thank you, Mr. Matuku. Commissioner Brazil?
Okay, I was just going to move, we go to closed session.
All right, that would answer the question. We will now adjourn to closed session. I believe we're going to the conference room. Okay. Thank you for everyone's patience for us there. I believe there are there additional questions from the commission for anyone?
Yes, Mr. Chair.
Commissioner Ewell.
During during Mr. Matuku's conversation with the commission, he stated that there were in fact other options to go from his patrol car into the building, is what the report states. But he states that he was going into his car, personal vehicle. Could you clarify that, please?
The way as it was explained to me by the case agent that did the internal affairs investigation, and then from my personal observations from watching the surveillance video, he was walking towards the police building. There was personal cars that were parked beyond where he parked his patrol car, but at least when he was walking out of the camera's view, he was walking towards the police station. I never saw him walk the other way.
So based upon your understanding, he could not have been walking toward his personal vehicle, but walking toward the door. Is that fair?
Not what I observed or was told. And he was in uniform too.
Commissioner Nieto, I need clarification. So what you're saying is that the direction he was walking was towards the door. Were personal vehicles beyond, if it would look like I was walking towards the door, but I may be going to my personal vehicle?
So the personal vehicles were parked in the opposite direction of where the police building was, if that makes sense.
I could provide clarification if I may, Commission.
Go ahead. Ms. Matuku.
So on the surveillance video, which I'm not sure if you guys were provided or not, the direction in which I'm walking is I'm not trying to argue that it's not towards the police station. It is towards the police station. On the weekends, it was my general practice to park my personal vehicle in the what they call the watch commander's row. That row of parking spots is not seen on video and is literally directly to the front of the station. So again, and I'm just offering the statement of fact that I was seen walking towards where my personal vehicle would have been, which is towards the front of the station. And like my argument has been this whole time, a simple key card reader would have shown either way, whether I went in or I didn't go in. So that's all I'm saying, that there's definitely a parking lot with personal vehicles, specifically sergeants who sometimes use, to the front of the police station in the watch commander's row.
Mr. Chair, may I comment briefly?
Mr. Henley, please.
And for the members of the commission, an important fact I would urge you to consider here is we've heard Mr. Matuku's description. And you may have heard something different. I did not hear Mr. Matuku say affirmatively one way or the other whether that video is him walking to his car or not. I've heard him say it could have been that he was walking to his car, or it could have been he was not. An important fact from my perspective, based on what we know and what Mr. Paletta has stated, is Mr. Matuku was in uniform at the time of this video. So I think an important fact for you to consider is, was Mr. Matuku, while in uniform, walking to his personal car to drive home in uniform? Or was Mr. Matuku, while in uniform, walking towards the building? That's something for you to decide what that video means. And I would respectfully submit that you should consider that video within the context of the other facts. Those facts including, but not being limited to, that his fingerprints are found within a vinyl sleeve. 2 fingerprints of Mr. Matuku are positively identified. That within 36 minutes of the video of Mr. Matuku in uniform walking towards the building, someone downloads from the station, downloads the flyer, and prints the flyer. All of these facts happen within 36 minutes of that video of Mr. Matuku walking towards the station. We would respectfully submit That evidence alone, although there's much more evidence corroborating it, that evidence alone demonstrates there is a high probability that Mr. Matuku was dishonest when he said he did not ever see, touch, or post the flyers.
Commissioner Ewell, has your question been answered to your satisfaction at this point?
Yes, sir. Thank
All
you.
right, all right.
In response to that,
Be brief, Mr. Gage. The commissioner's question has been answered, so go ahead.
okay, in response to that, the division has the burden of proving by clear and convincing evidence that Sergeant Matuku was in the station. They have not and cannot do it. The surveillance video does not show him entering. There's a key card that would show if he entered or not. They have not produced any evidence showing that he used a key card to enter the building. There were other officers that were in that building that could have done the printing, and they didn't do it. He talks about a fingerprint being found on the vinyl sleeve, which is far different than being found on the wrap poster itself. Sergeant Matuku would have used a vinyl sleeve for all kinds of police work, and it would be easy for someone to take
Let
that.
me interrupt you just a moment, Mr. Gage. I believe Mr. Henley just spoke and said that the fingerprint was on the poster itself, not the sleeve, correct?
It was on the paper itself, the flyer
I
itself.
just want to clarify.
Okay, thank you. Then I misunderstood him. And we just go back to the equivocalness of the three different fingerprint experts in Exhibit 4 to my letter.
Chair Long, I have a point of order.
Point of order, Commissioner Brazil.
This is not an evidentiary hearing. The question was asked and answered.
Right.
It was not asked of council. So I would suggest that we move forward, please.
But I granted you a brief response, Mr. Gage, but the question, as noted, has been asked and answered.
Thank you.
All right. Any questions from commissioners? Comments?
Yeah, I just want to make sure, I just want to, because we had a back and forth, I just want to make sure we're clear that Sergeant Matuko's fingerprints were on the flyer that he denies knowing anything about, and it was inside of a sleeve that was posted onto the locker.
That's correct, inside the sleeve.
Thank you.
Will the committee, is there a motion?
I would like to make a motion with a comment before the motion. I find the internal affairs investigation lacking in many, many areas. And unfortunately, staff has to deal with those investigations. So I find it very lacking. However, with the facts and the fingerprints on the paper inside the sleeve, and that the sergeant denies ever seeing it, ever touching it, knowing anything about it, I move for revocation.
Second.
Mr. Knapp, please call the roll.
Thank you, Mr. Chair. Commissioner Barcelona,
No.
Commissioner Braun.
No.
Commissioner Brazil,
Yes.
Commissioner Cooper,
No.
Commissioner Doring.
No.
Commissioner Ewell,
Yes.
Commissioner Gordon,
No.
Commissioner Johnson,
Hey.
Commissioner Long,
Yes.
Commissioner Moon,
No.
Commissioner Nieto,
No.
Commissioner Rodriguez, Commissioner Terrio,
No.
Commissioner Woolry.
No.
We have 3 yes votes. The motion fails.
Thank you, everyone. Take a breath and we'll move to our second case. Law enforcement consultant William Imbeden, Professional Conduct, LA County Bureau, and Chris Becker, Post Assistant Chief Counsel, will provide a report on case 2307511, Cifredo Cano, who at the time of the events of this case was employed with the LA County Sheriff's Department. Gentlemen.
Morning, Mr. Chair, members of the commission. My name is William Imboden. I'm a law enforcement consultant assigned to the Professional Conduct Bureau, Los Angeles County. And with me today is Christopher Becker, an attorney with our Legal Affairs Bureau. I'm here with respect to the case of Post versus Deputy Cifredo A. Cano, formerly of the Los Angeles County Sheriff's Department. In this case, the division found reasonable grounds to believe that Deputy Cano engaged in serious misconduct in violation of Penal Code Section 13510.8 on or between May 14th, 2021 and July 22nd, 2021. Specifically, the division has determined that Deputy Cano committed the following acts of serious misconduct: abuse of power, including but not limited to intimidating witnesses, knowingly obtaining a false confession, and knowingly making a false arrest, and sexual assault, as described in subdivision B of section 832.7, which states, quote, "Sexual assault means the commission or attempted initiation of a sexual act with a member of the public by means of force, threat, coercion, extortion, offer of leniency, or other official favor, or under the color of authority." For the purposes of this definition, the propositioning for or commission of any sexual act while on duty is considered a sexual assault. And for dishonesty, relating to the reporting, investigation, or prosecution of a crime, or relating to the reporting of or investigation of misconduct by a peace officer or a custodial officer, including but not limited to false statements, intentionally filing false reports, tampering with, falsifying, destroying, or concealing evidence, perjury, and tampering with the data recorded by a body-worn camera or other recording device for purposes of concealing misconduct. In the division's investigative summary and findings, it recommended revocation of Deputy Cano's post-certification. In accordance with the requirements of Senate Bill 2 and as required by Penal Code Section 13510.85, subsection A4, this matter was heard by the Peace Officer Standards Accountability Advisory Board on October 17th, 2024. Following the conclusion of that hearing, the board voted to recommend revocation of Deputy Cano's certification, and the division asks that you adopt that recommendation today. As required by Penal Code Section 13510.85A5, the record of that proceeding is before you, which includes the agenda and attachments from that meeting, a transcript of the relevant portions of that hearing, and the recommendation of the board. If the matter was heard in closed session by the board, commission counsel will be able to advise you with respect to those proceedings. The law requires your review to be of that record and before the board, that record before the board, which is before you and which you haven't had an opportunity to review. To assist you in your review of the record, I'll take you through the case as presented there. As the record shows, I presented the case before the board substantially as follows. Cifredo A. Cano began his career with the Los Angeles County Sheriff's Department on November 30th, 2007, and at the time of his termination from the Sheriff's Department held basic, intermediate, and advanced post certificates. LASD records indicate Mr. Cano had one prior sustained allegation of misconduct. In March of 2017, Mr. Cano received a 2-day suspension for policy violations when he failed to document a crime and book evidence in a timely manner. Mr. Cano received a fictitious $100 bill from a business owner, but did not write the report or book the evidence until after the victim followed up with the agency days later and was discovered Mr. Cano still had the evidence in his possession. On May 13th, 2021, Mr. Cano met the victim in this case that we're here to discuss in his capacity as a peace officer during her arrest for driving under the influence of alcohol. He then used his position of power and influence to initiate personal contacts with the victim to leverage his position as a peace officer to obtain a romantic relationship with the victim. On May 13th, 2021, Mr. Cano told the victim he could make her DUI go away if she would go out on a date with him, saying he would try his best to get the arresting deputy to not show up in court. The evidence demonstrates that Mr. Cano attempted to make good on this promise when he approached that deputy and informed him that he had spoken to or with the victim and learned that this would be her second or third DUI. The arresting deputy confirmed he interpreted that conversation to mean that he should not attend the court hearing. Also on May 23rd, 2021, Mr. Cano deceitfully had his partner access the DMV database to run the registration of the victim's vehicle before meeting with her for lunch. And then later that same day, after his partner went off shift, Mr. Cano used the partner's secure login information to access CLETS to check the victim for warrants and wants while meeting with her a second time that day. He then showed the victim the confidential results of that query. Further, between May 14th and July 22nd, 2021, Mr. Cano initiated and maintained a text and phone relationship with the victim after getting her cell phone number from the arresting deputy's DUI report. The initial text message from Mr. Cano to the victim was sent the day after she was arrested and shortly after she was released from LASD's jail. Additionally, Mr. Cano conduct amounted to a sexual assault as described in Penal Code Section 832.7, in that he attempted the initiation of a sexual act with a member of the public while on duty and through officers of leniency or other official favor. Between May 14th and July 22nd, 2021, Mr. Cano and the victim exchanged approximately 100 text messages, many of which are Mr. Cano asking the victim to meet with him, asking her out on dates, telling her how sexy she is, asking for pictures of her, and on one occasion reminding her that she was not wearing underwear the night she was arrested. During his IA interview, Mr. Cano eventually admitted to initiating contact because he was attracted to the victim and wanted to establish a relationship with her. He said he knew it was a violation of department policy and was wrong. On May 23rd, 2021, according to the attorney representing the victim, Mr. Cano implied to the victim he could make her DUI arrest go away if she would go out on a date with him. At that meeting, Mr. Cano was on duty in his patrol vehicle and met the victim outside a restaurant where she was with friends. Later that day, Mr. Cano met with the victim again while on duty in front of her friend's home. The victim got into the patrol vehicle at Mr. Cano's request and sat in the front passenger seat while Mr. Cano accessed the computer to check the victim for warrants and wants. At one point, Mr. Cano asked the victim to go out with him. When she said no, Mr. Cano touched her face and told her he, quote, wanted to be with her, with a clear meaning he meant in a sexual way. He then kissed her cheek and told the victim, quote, "You're so sexy." This account was corroborated through an audit of the MDC usage in Mr. Cano's patrol vehicle for May 23rd, 2021, and confirmed when the division interviewed the victim on July 15th, 2024. Finally, clear and convincing evidence supports dishonesty occurred in relation to the investigation of misconduct by a peace officer in the form of false and misleading statements made by the subject deputy, Mr. Cano. This is supported by text messages between Mr. Cano and the victim, GPS timelines of Mr. Cano's movements, and call logs from a witness cell phone, as well as statements from the victim. The evidence is corroborated by statements from witness deputies and the Los Angeles County Head Deputy District Attorney. Mr. Cano was dishonest during his 3 compelled interviews until he was confronted with physical evidence contradicting his statements. The following examples highlight this pattern. At the beginning of the administrative investigation, Mr. Cano remembered minute details of the DUI crash, including the victim's description, but said he could not remember her name. When the investigator showed him the collision report, Mr. Cano read the victim's name and said that must be her name because she was listed as, quote, party 1, and whoever's party 1 is the person who is at fault in the collision. This despite months of text messaging with the victim, requesting her Instagram contact, pursuing her romantically, and providing professional favors for her. At one point, Mr. Cano mentioned offhand that he met with the victim at a specific location because she lived nearby, but he couldn't remember her name when he was asked by IA. Mr. Cano told Internal Affairs he had no contact with the victim after the night of her arrest for DUI on May 13th, 2021, until she contacted him several weeks later at a traffic stop, a statement the victim later said was false. IA then presented Mr. Cano with 28 pages containing over 100 text messages between Mr. Cano and the victim that Mr. Cano initiated beginning within hours of her release from jail on May 14th, 2021. Only then did Mr. Cano admit to some interactions with the victim. Mr. Cano told IA very explicitly that he had no memory of transporting the victim to the hospital the night of her arrest. Although they showed him hospital paperwork he signed for her release, agency call logs showing he transported her to the hospital, and transcripts showing he and his partner were transporting, quote, a female to the hospital. Yet in the very first text message to the victim on May 14th, 2021, Mr. Cano reminds her that he was the deputy that transported her to the hospital. Mr. Cano denied using the patrol vehicle computer to check the victim for warrants or run her driver's license on May 23rd, 2021. In a subsequent interview, the IA investigators were able to present Mr. Cano with records showing his computer was used to check the victim for warrants and license status at a time when only Mr. Cano was using that vehicle, even though the login information was Mr. Cano's off-duty partner's login information. Mr. Cano told IA he must have, quote, ran her then, but he didn't remember doing it. In her interview, the victim stated she sat in the front seat of the patrol car on May 23rd, 2021, while Mr. Cano checked her for warrants and ran her driver's license and gave her the results. During her interview with the division, the victim stated she was sitting in the patrol car at Mr. Cano's request while he checked her for warrants on the computer. Mr. Cano told her that her driving record was, quote, not good. Mr. Cano stated he met the victim on 3 occasions, but stated each time was brief, only about 5 minutes each. However, GPS tracking on his patrol vehicle showed that Mr. Cano met with the victim on May 21, 2021 at Temple High School for 18 minutes. He then met with the victim on May 23, 2021 outside the Hilton Hotel for 40 minutes, and then again on May 23, 2021 in Rosemead for an additional 21 minutes. Mr. Cano denied speaking to the deputy that arrested the victim for DUI in an attempt to dissuade him from testifying against the victim. Mr. Cano said he had not talked to that deputy at all or engaged in any type of conversation with him since the night of the victim's arrest, May 13, 2021. During his IA interview, the arresting deputy stated Mr. Cano approached him in the station a few weeks after the victim's arrest and struck up a conversation with him about her prior DUI arrests. Additionally, the deputy provided a screenshot of his cell phone showing he missed a call from Mr. Cano on November 14, 2022, and a screenshot of a connected call with Mr. Cano 1 hour later that lasted 7 minutes and 20 seconds. That missed call came in 1 hour and 10 minutes after Mr. Cano finished his second IA interview, where he stated he had not talked to the arresting deputy about the victim or her case. On November 21, 22, Mr. Cano had a third interview with IA where he changed his answer and admitted having conversations with the arresting deputy, but said not about the victim or his ongoing IA. The facts I've just recited support the division's finding that Cifredo A. Cano was involved in serious misconduct, specifically abuse of power, sexual assault, and dishonesty. For purposes of the division's analysis, clear and convincing evidence means evidence of a charge is clear and convincing so long as there is a high probability that the charge is true. The evidence need not establish a fact beyond a reasonable doubt. The division recommends that Cifredo A. Cano's post-certification be revoked. And the division's recommendation is based on the following serious misconduct: abuse of power, where Mr. Cano accessed confidential records to obtain the victim's phone number in an effort to contact her to establish a professional relationship, deceived co-workers to surreptitiously access her criminal and driving records, and attempted to dissuade the arresting deputy from appearing in court in an effort to influence her criminal case. And sexual assault, where Mr. Cano committed or attempted the initiation of a sexual act with a member of the public by an offer of leniency or other official favor and under the color of authority. Specifically, Mr. Cano offered official favors, attempted to influence the victim's criminal case, and met with her while on duty, kissing her cheek and telling her how sexy she is in an effort to establish a quid pro quo sexual relationship. And dishonesty, as it pertains to the investigation of a peace officer, where Mr. Cano was repeatedly dishonest and gave misleading statements to IA investigators until presented with factual evidence of his deceptions, at which time he admitted his actions and deceptions to the extent they had been proven, but no further. Following my presentation to the board, and as documented in the transcripts before you, the following public comments were made by Mr. Cano. Mr. Cano stated that his representative had to leave the hearing prior to his case being presented. Mr. Cano stated that that a lot of what was presented was not true. He stated he did not make any promises to the victim, that she was not in his vehicle, that he never asked for favors, and that he got her phone number from the traffic report that he wrote, not the arresting deputy's report. Members of the board had no questions for either myself or Mr. Cano. The board then went into closed session. When they returned to open session, voted to revoke the officer's certification unanimously. With that, I'm happy to answer any questions the commission has.
Commissioner Moon?
No questions. I do ask for a motion to decertify Mr. Cano.
Commissioner Terrio, second.
Second, Cooper.
We have a motion. We have a second.
Chair Long, I believe that Mr. Cano's counsel.
Before we do that, let's hold that in abeyance. Would anyone like to testify on behalf of Mr. Cano?
Good morning. I am Mr. Cano's legal counsel, and I'd like to make some public comments concerning this matter.
Please, sir, go ahead.
Good morning, everyone. I understand the procedural posture we're in. There's not a hearing. This is not a formal evidentiary hearing. So I'm going to just address some of the allegations in order for this committee to vote on this pending motion. This case arose obviously out of the LASD's internal affairs case. And I want to stress that the victim in this case was never interviewed. The allegation of this purported sexual assault was provided to the Temple City Station's captain from the DA's office, who then forwarded an email from this alleged victim's attorney. And that's on page 418 of the packet that was produced to us. So this notion that this a quid pro quo occurred doesn't arise to anything close to clear and convincing standard. This is a out-of-court statement by the attorney who represents the DUI suspect at that time. That alleged victim ultimately took a plea of a wet reckless. There was a notion about a false arrest, which never occurred. The underlying arrest had sufficient probable cause. The alleged victim was drunk. She hit a car, and that's all there was to it. There were allegations of some purported issues with intimidation of witnesses. The deputy in this case, Deputy Edward Chen, he was the deputy that took the arrest from the crash. He never said in any of his internal affairs interviews that my client approached him and asked him not to go to court. That was his speculation. There was not even an ounce of evidence that my client told Deputy Chen, hey, don't show up to court because I'm trying to date this gal. There's nothing in the record to support that notion. That is a speculation again. This attempted sexual act on duty. I mean, I think the evidence is undisputed that my client met with this alleged victim on duty. They had a consensual encounter. They had a meal. My client didn't eat at that restaurant, and they did meet up again at the Temple City High School. No evidence of any kind of sexual conduct or misconduct occurred in these meetings. I want to get into this accessing confidential files. I think that has to do with the abuse of powers, because that is an important allegation for me to address. And I want to go into this attachment that you all received, which is a 6-page attachment labeled BR4. And what that is a unit log of my client's mobile digital computer. And you will see that at 4:09 p.m., there was an inquiry ran of the license plate. What you don't have in front of you is where my client was located at that time. What you don't have is what my client was doing. If you look at his internal affairs interviews, he would say that he was actually writing his report. So he had a business reason to run the license plate because my client was finishing up a supplemental report for traffic collision. To the extent that there were consensual text messages between the young lady and my client, those were consensual. There was nothing quid pro quo. You're not going to see any kind of text messages from my client to that young lady. Hey, if you go out with me, I'll make the case go away. In fact, my client wasn't even the arresting officer. So this notion of, hey, abusing your power to use your power of authority and gain that leverage to an arrestee, that is a pure speculation that never occurred. What did occur was my client was attempting to have a romantic relationship with her. That is consensual. Those text messages were consensual between the alleged victim and my client. That's undisputed. I don't think you get decertified or go to an ALJ hearing for talking to someone in a consensual manner. She was an adult, he was an adult. I think where things are in dispute is why and whether or not there was a quid pro quo of sexual favor in exchange as the arresting or as the one of the deputies who was present at the arrest, whether they had some type of deal to have sex with with that young lady, with my client. That never occurred. There was no arrangement of that, and none of that ever occurred. So I think this framing of my client abusing his powers in exchange for sexual favor or sexual assault is nothing more than a pure speculation. Lastly, I want to address this issue of dishonesty. Number one, perjury requires someone to be under oath. My client was never under oath in any of these proceedings, so I'm not sure why there is a perjury allegation. As far as the dishonesty allegations go, the interview occurred approximately 16 months after the alleged misconduct. So 16 months later, my client's confronted with, hey, how long were you at this particular location at the Hilton Plaza? He says, I don't know, maybe 10 minutes. It turns out it was like 30 minutes. Hey, how long were you at the Temple City High School? 16 months later, he was asked, oh, I don't know, maybe 10 minutes again. I don't remember. Those are the basis of the alleged dishonesty that the sheriff's department imputed my clients with. So I think this notion of, hey, he intentionally misled investigators because he didn't remember the duration of where he was at and how long he was there. I don't believe that is I don't believe those kind of responses rise the level of dishonesty. My client also indicated that he knew there was GPS data on the car. So the natural question is, why would he conceal the duration in which he was present with this alleged victim if he knows and he knew that there were GPS data capturing that duration? I think the internal affairs investigators could have said, hey, is this your car? Do you dispute this duration? But instead, there's this trickery that occurred at the internal affairs interview that imputed this dishonesty allegation on my client. I welcome any questioning, and thank you very much for your time.
Thank you, Counselor. Are there any questions? Okay, could you please state your name for the record, sir?
Yes, I'm sorry, I did not do that earlier. My name is Tom Yu, Tomyu.
Thank you very much. Thank you very much.
Chair Long, can I just speak very briefly to the points that were made?
Mr. Becker.
Thank you. Just very briefly, because I know that, we've been here for a little while already. So there was an allegation made by Mr. Yu that the victim was never interviewed in this case. That's actually not true. Mr. Imboden, during the course of his investigation, did interview the victim to corroborate her statements, and that is in the investigative summary and findings. Second, talking about the criminal charge that was eventually turned into a complaint that was turned into a plea. It was charged as a standard DUI against the victim in this case, but because of Mr. Cano's actions, the DA, and this is also in the investigative summary and findings, had to lower the complaint to a wet reckless. It was a standard DUI. It was a prior. It was a 0.23. And because of Mr. Cano's actions, the DA had to lower it and give her a lesser charge to save the prosecution. And then the third point, just being brief, Mr. Yu said that something about this not amounting to perjury because he wasn't sworn to testify. That's not the standard here today. The standard is under 13.510.8, dishonesty, and he was dishonest in the course of a serious misconduct investigation. That's not perjury. They're totally different. With that, I would submit.
Thank you, Mr. Becker. Are there questions or comments from anyone else in the audience on this particular case? Seeing none, if there are no more questions or comments from the commission, we have a motion, we have a second. Mr. Knapp, would you please call the roll?
Yes, Mr. Chair. Commissioner Barcelona,
Yes.
Commissioner Braun,
Yes.
Commissioner Brazil,
Yes.
Commissioner Cooper,
Yes.
Commissioner Doring,
Yes.
Commissioner Yule,
Yes.
Commissioner Gordon,
Yes.
Commissioner Johnson,
I vote yes.
Commissioner Long,
Yes.
Commissioner Moon,
Yes.
Commissioner Nieto,
Yes.
Commissioner Rodriguez, Commissioner Terrio,
Yes.
Commissioner Woolry.
Yes.
Unanimous, motion passes.
Unanimous motion. Thank you very much. Thank you, Mr. Vu. Our next case. Law enforcement consultant Kevin Sherburne, professional conduct, Central Bureau, and Bryant Henley, Post Legal Affairs Bureau will report on case 2313715. Hae Bermudez, who at the time of the events in this case was employed with the Daly City Police Department. Gentlemen.
Good morning, Commissioners. Thank you for your time today. My name is Kevin Sherburne. I'm a law enforcement consultant. I work for the Central Bureau for Professional Conduct in the Professional Standards Division. I served as the investigator in the case involving Hae Bermudez, who was employed by Daly City Police Department at the time of the serious misconduct. The case number is post 2313715. The division in this case found clear and convincing evidence and reasonable grounds to believe that Mr. Bermudez engaged in serious misconduct in violation of California Penal Code Section 13510.8 B6, based upon 2 DUI convictions. The division recommended to the Peace Officer Standards Accountability Advisory Board that Mr. Bermudez's post certifications be revoked, without taking a position regarding whether a stay of revocation would be appropriate in this case. Counsel for Post provided background on 2 other cases that the division brought that involved substance abuse and explained how those cases were resolved. Counsel for Post is sitting next to me, Mr. Bryant Henley, and he was the individual who explained to the board with those division's position. In accordance with the requirements of Senate Bill 2 and as required by Penal Code Section 13510.85A4, the board heard this case on October 17, 2024. Following the conclusion of the hearing, the board voted unanimously to recommend revocation of Mr. Bermudez's certifications and to stay revocation under certain conditions. In accordance with Penal Code Section 13510.85A5, the record of that proceeding is before you today, including the agenda and attachments from that meeting, a transcript of the relevant portions of the hearing, and the recommendation of the board. The law requires your review to be of the record before the board, which the division has provided to you, in which you've had an opportunity to review. As presented to the board, the clear and convincing evidence substantiated that Mr. Bermudez violated California Penal Code Section 13510.8 B6. Mr. Bermudez was convicted twice for drunk driving. These acts are sufficiently egregious or repeated as to be inconsistent with the peace officer's obligation to uphold the law or respect the rights of members of the public. Mr. Bermudez worked for Daly City Police Department for nearly 11 years, from 2012 to 2023 when he was terminated. Post issued 3 certificates to Mr. Bermudez, including basic, intermediate, and advanced. In 2015, the Campbell Police Department officers arrested Mr. Bermudez for DUI. He was off duty at the time. He had collided with a fire hydrant, causing major damage to the driver's side of the vehicle, and he had a passenger in the car. His blood alcohol content by volume measured 0.19%. He pled nolo contendere and was convicted. The court sentenced him to volunteer work, counseling, and fines. In 2022, Walnut Creek police officers arrested Mr. Bermudez for DUI. He was driving a government-owned vehicle and was on call as a drug interdiction task force member at the time. He had a civilian passenger in the car. His blood alcohol content measured 0.269% by volume, and in addition to alcohol, Mr. Bermudez tested positive for THC at the rate of 5.9 nanograms per milliliter. On December 6, 2023, he pled nolo contendere to this charge and was convicted. The court sentenced him under a statute that provided for a sentencing enhancement because it was his second DUI conviction within 10 years. The 2023 conviction included a sentence of 20 days in jail. Daly City Police Department conducted an internal affairs investigation in both instances. Because, in accordance with its record retention policy, it purged the 2015 file, it's unclear whether the investigation sustained any findings what the allegations were, and if sustained, what discipline, if any, the department imposed. In the 2022 DUI, Daly City Police Department's internal affairs investigation resulted in sustained findings that led to a recommendation of termination. During his internal affairs interview, Mr. Bermudez stated that he had put himself through a 30-day inpatient rehabilitation program, was undergoing outpatient treatment, was attending Alcoholics Anonymous meetings, and was at the time of the interview 80 days sober. Mr. Henley, counsel for Post, also spoke to the board on behalf of the division. Mr. Henley briefed the board on 2 prior cases where the commission determined that a revocation of certificates was stayed pending terms and conditions of probation based on substance abuse. Mr. Henley also stated that he and I had met with Mr. Bermudez and answered questions that he had about an alternative resolution process. At Chair Dudley's suggestion, Mr. Henley explained to board members the types of terms and conditions that were imposed in the previous cases and the process by which the stayed revocation was imposed. During the meeting, board members Clavo, Glazer, Buchan, and Johnson asked questions about the facts of the case, processes for implementation of a stay of revocation, and the effectiveness of terms and conditions. They also asked about the scope of substance testing and how an employing department might assign a peace officer who is the subject of a stayed revocation. Details about the information exchanged during the meeting is contained in the transcript at pages 234 to 46 and 249 to 52. Following the presentation to the board and as documented in the transcript, the board received public comments, including from Mr. Bermudez. He said he did not dispute or deny the division's presentation of the facts, and he took ownership of his poor decisions and held himself accountable. He also stated that he was headed down a path of self-destruction and had to accept that he was powerless to make changes on his own, so he checked himself into a 30-day inpatient rehab facility. He completed that program in a 2-week outpatient program. He attends an 18-month DUI program on a weekly basis. He stated he has a passion for serving the community as a peace officer and has a lot more to offer the community if given a chance for a future as a police officer. Chair Dudley asked Mr. Bermudez about his sobriety length and how many days he has been sober and about THC. He responded that he has remained sober for the ensuing 2 years and 2 months since his DUI arrest and that he took what he thought were CBD pills to help him sleep. At the conclusion of Mr. Bermudez's statements, board members provided additional commentary about substance abuse. A member of the community also addressed the board and provided general public comment. These comments are contained in the transcript of the hearing. The board then went into closed session, and when they returned, it voted to revoke with conditions Mr. Bermudez's certifications unanimously with 7 members of the board present. At this point, I'm happy to answer any questions the commission members may have.
Questions? Questions at this point? Or does Officer Bermudez and or his counsel wish to speak? Don't believe we're aware. He's online? I'm not speaking. You understand Officer Bermudez is, or Mr. Bermudez is on the line. He does not wish to speak, apparently.
Hello?
Mr. Bermudez?
Yes, sir. I have no further to add.
Thank you, sir. Thank
Okay.
you for listening in. Does anyone from the public wish to address the commission on this case? What is the will of the commission? We can go to closed session. I see nods. We will adjourn then to temporary for a closed session. Thank you. Could everyone take their seats and we'll try to move this along? Mr. Knapp, could we ask you to call the roll for absentee members?
Yes, sir. Commissioner Rodriguez.
And also, before we get back to the agenda, pretty much we all know, but for those in the audience and so forth, congratulations are in order to Commissioner Michelle Rodriguez, who is now Assemblywoman-elect Rodriguez. She'll begin representing the 53rd Assembly District December 2nd. So today will be her final day with us. Congratulations are in order. We thank you for your service to post and we wish you the best. You're an Assemblywoman now. There should be a speech. There it is.
That's why I'm going to Sacramento, because I don't give those long
Then
speeches.
you listen to Mr. Cooper, there'll be a speech. There's an opportunity for a speech here. Thank you. Thank you very much. Back on. Are there any, coming back in here, are there any questions or comments additional from the commissioners? Otherwise, I will ask for the will of the committee as to a motion.
Commissioner Nieto.
The motion is to,
Commissioner Nieto motioning to revoke Mr. Bermudez's
is there a second?
certification.
Is there a second?
Second.
All right, Mr. Knapp, could you call the roll, please?
Thank you, Mr. Chair. Commissioner Barcelona.
No.
Commissioner Braun. Commissioner Brazil.
No.
Commissioner Cooper.
No.
Commissioner Doring.
No.
Commissioner Yule. Commissioner Gordon.
No.
Commissioner Johnson.
No.
Commissioner Long.
Yes.
Commissioner Moon.
No.
Commissioner Nieto.
Yes.
Commissioner Rodriguez.
No.
Commissioner Terrio.
Yes.
Commissioner Woolry.
No.
Motion fails.
The motion. Good motion.
I'd like to make a motion that we enter into a stipulated agreement and stay revocation consistent with past agreements related to driving under the influence of alcohol. Also, within that motion, ensure that THC is a prohibited substance within that motion for the appellant.
Second.
I'll second.
Mr. Knapp, would you call the roll, please?
Commissioner Barcelona.
Yes.
Commissioner Braun.
Yes.
Commissioner Brazil.
Yes.
Commissioner Cooper.
Yes.
Commissioner Doring.
Yes.
Commissioner Yule.
Abstain.
Commissioner Gordon.
Yes.
Commissioner Johnson.
Yes.
Commissioner Long.
Yes.
Commissioner Moon.
Yes.
Commissioner Nieto.
Yes.
Commissioner Rodriguez.
Yes.
Commissioner Terrio.
Yes.
Commissioner Woolry.
Yes.
Motion passes.
Thank you, Mr. Knapp. Our final case for the day. Law enforcement consultant Kevin Sherburne, Professional Conduct Central Bureau, and Carrie Woolley, Post Legal Affairs Bureau, will now provide a report on case 2300017, Paul Matachic, who at the time of the events in this case was employed by the Brentwood Police Department. Floor is yours.
Thank you, Mr. Chair. Good morning again, commissioners. It is still morning. Thank you for your time. I appreciate it. I'm going to repeat some of what I said before with respect to Mr. Bermudez's case so that for purposes of the transcript, this case is considered independent and separate and it's easier to read in a transcript. My name is Kevin Sherburne. I'm the law enforcement consultant who served as the investigator on this case. With me today to my right is Ms. Carrie Woolley. She's legal counsel for Post. I serve in the Central District of the Professional Conduct Bureau's scheme within the division. The case number for this case is Post 2300017. The division in this case found clear and convincing evidence and reasonable grounds to believe that Mr. Matachic engaged in serious misconduct in violation of California Penal Code Section 13510.8 B3, based upon physical abuse, including excessive or unreasonable force. The division recommended to the advisory board that Mr. Matichek's post certifications be subject to discipline, either suspension or revocation. In accordance with the requirements of Senate Bill 2, and as required by Penal Code Section 13510.85A4, the board heard this case on October 17th, 2024. Following the conclusion of that hearing and after hearing from the respondent and his counsel who were present in person, the board voted unanimously to recommend revocation of Mr. Matichek's certifications. The division presents this case today to the commission for determination of discipline. In accordance with Penal Code Section 13510.85A5, the record of that proceeding is before you today, including the agenda and attachments from that meeting, a transcript of the relevant portions of the hearing, and the recommendation of the board. The law requires your review to be of the record before the board, which the division has provided to you and which you've had an opportunity to review. As presented to the board, the clear and convincing evidence substantiated that Mr. Matichek violated California Penal Code Section 13510.8 B3 when he used force against a homeless woman that was unreasonable or excessive, either or both. Taking into account Mr. Matichek's perspective, as well as the perspective of the other officers present, the woman did not objectively pose a threat to Mr. Matichek or anyone else, including the other officers, was not resisting, and was not attempting to escape. As background, Mr. Matichek started working for Brentwood Police Department in 2017. Post issued him basic and intermediate certificates. He remained with the Brentwood Police Department until his termination in August 2022. This case stems from a call for service to a home improvement store in Brentwood on April 23rd, 2022. At approximately 5:30 in the morning, Brentwood Police Department received a call that someone was screaming near the garden sheds. 3 officers responded to the scene. Officers Josh Flynn and David Franson and Mr. Matichek. There, the officers found victim 1, a homeless person who was known to Mr. Matichek and the other officers, inside one of the sheds. The officers ordered her outside, where Mr. Matichek placed her in handcuffs behind her back and placed her in a seated, cross-legged position in front of the open door to the shed. Her back was to the open door of the shed. For the next 7 or so minutes, the officers positioned themselves around victim 1 and engaged in conversation with her. The conversation alternated between being verbally abusive, using foul language, and routine conversation. The officers later stated that she appeared to be drunk, and based upon her comments, that she said that she had been shot in the nose by a laser, possibly under the influence of illegal drugs. After about 7.5 minutes, victim 1 started to stand up. As she was in the process of standing, her hands were still cuffed behind her back. Officer Franson's body-worn camera showed that Mr. Matichek took 3 quick steps toward victim 1, kicking her with his right foot in her left midsection or upper thigh. Victim 1 fell backwards into the open door of the shed, hitting the door and falling to the ground. Mr. Matichek later said he feared that she would spit at him. He told the IA investigator, however, that she had never actually hit him in the face with spit. The hearing officer rejected Mr. Matichek's statement of fear as, quote, speculative and the exact type of 20/20 hindsight analysis the Supreme Court forbids, end quote. After Mr. Matichek kicked victim 1, he brought her to her feet and escorted her to his patrol car. Officers Flynn and Franson walked behind him at the time. They later stated they expressed surprise to themselves about the kick because there was no threat of harm or safety issue that required the use of force or that level of force. Mr. Matichek did not take responsibility for his wrongful actions. In fact, Officer Flynn noted that he and Officer Franson told Mr. Matichek they would take over after victim 1 was at the patrol vehicle. Mr. Matichek's response, quote, he smiled at us, end quote. The officers summoned an ambulance where EMTs determined victim 1 did not require medical treatment. That victim 1 may not have sustained injury is irrelevant to the issue whether revocation or suspension is warranted. The focus is on Mr. Matichek's acts constituting physical abuse. Respondent arrested victim 1 for public intoxication and battery on a peace officer because she later spat at a community services officer who was preparing to transport her to the county jail. I'm going to show you today some video footage of Mr. Matachic's use of force. There's 2 video perspectives to show. The first video perspective is Mr. Matachic's own body-worn camera, and the second is from Officer Franson's body-worn camera. In discussing the video, I'm going to refer to the time of day rather than the timeline on the bottom of the screen. The time of day is noted at the top in the upper right corner. If you could please show video 1.
Hey, what's your ass? Sit down, sit down, sit down, sit down.
What?
Sit down,
What are you
sit down,
doing, dude?
sit down.
Ow, what are you doing, dude?
Put your hands behind your back,
Why?
because I said so.
I fucking just got shot in my fucking nose, dude. I got shot in my nose.
Can I get some light over here? Your stuff.
Oh, what?
Drop your stuff.
Oh. Someone just fucking shot me in my nose. Thank God you guys fucking did it.
Why didn't you step outside when we told you to?
Because I didn't know who it was.
We said police department.
Oh, somebody shot me in my nose. They fucking shot me in my nose. Dude, look. On the corner of it.
Shot you in your nose?
Yeah.
With what?
I have no clue. It looked like a laser.
Who was it?
It was that guy with the one with the hawk nose or whatever.
The hawk nose?
Yeah.
I don't know what you're talking about.
He called me up or whatever, and he's like, hey, he's like Alex Sloan, he's like the original, he's like stop by, he's like tough shit or whatever.
What do you look like?
Fucking like a big ass fucking nose full.
Yeah, but like, was he black, white, Hispanic? What happened?
He was Mexican.
He's Mexican?
Yeah.
And looking at that video, we see that from the initial contact when the officers recognized victim 1 to Mr. Matachic's placement of the handcuffs on victim 1, the officers had the situation under control. Mr. Matachic immediately recognized her and called her by her name. The audio is redacted. We didn't hear that part of it. Victim 1 did not display any behavior or words that would indicate she posed a threat to them or a risk of escape. She was compliant to commands to sit down, although she questioned why. She did not resist Mr. Matachic assisting her to the ground or placing her hands behind her back. The video showed that the physical placement of handcuffs on victim 1 only required one officer, Mr. Matachic himself. The other officers did not perceive victim 1 to be a threat or escape risk and stood some distance away. One of the officers provided light from a flashlight and the other explored the area in the shed. One of the officers turned off his body-worn camera as soon as he recognized victim 1. He would not have done so if he perceived that she was a flight risk or a threat risk. Further, the video showed that Mr. Matachic did not double lock the handcuffs or conduct a pat search of victim 1. Further evidence, he did not perceive her to be a flight or threat risk. Also important to note from that video is the handcuffing process itself. In the video, you saw that when Mr. Matachic applied the handcuffs to victim 1's wrists, he applied light pressure at first and adjusted them to a tighter position. The noise of the ratcheting of the handcuffs showed that Mr. Matachic did not apply them in an aggressive manner. The audio shows that Mr. Matachic and victim 1 engaged in a conversation free from emotion or stress. Again, the audio shows that Mr. Matachic did not ask victim 1 if she had any weapons, that this is evidence he did not perceive her to be a risk. For the next 5 to 6 minutes, Officer Franson's body-worn camera recorded the interaction between the officers and victim 1. I won't show you video 2. It's available if you'd like to see it. It's about 5 minutes long. That video is part of the record. Rather than showing you the video here today, I'll just briefly describe what occurred. During the conversation, victim 1 did not attempt to resist escape or pose a threat of harm to the officers. The officers learned enough during the conversation they believed victim 1 was experiencing a mental health episode. After the officers started asking her about her personal property and her consumption of alcohol, victim 1's demeanor changed. Mr. Matachic's conversational tone bordered on mocking victim 1, and he engaged in a sarcastic exchange with her. She then became verbally aggressive and started yelling and cursing. Officer Franson turned off his audio to his body-worn camera at 5:39 and 43 seconds in the morning. The video showed that officers triangulated victim one. She was effectively secured with her hands cuffed behind her back and seated cross-legged. Her back was to the garden shed. They were several feet away from her, and she did not pose a risk of threat or escape during this time. Would you please show video 3? Video 3 showed the officers continued to guard victim one in a triangulated position. While muted, the officers appeared to continue to engage her in conversation. About 8 minutes after initially being handcuffed and placed in a seated position, victim one attempted to stand up. At this point, Mr. Matachic immediately rushed toward victim one in about 3 steps and kicked her before she had even risen to a full standing position. The force with which respondent Mr. Matachic kicked victim one nearly picked her completely off the ground and backwards into the garden shed door, where she fell to the ground. At the time victim one stood up, she did not reasonably pose a threat to the officers or others, was not resisting, and was not attempting to escape. Officers Flynn and Franson did not even flinch when they saw her movements because they did not perceive her to be a flight risk or a safety risk. Would you please show video 4? That video clip showed the use of force in half-speed motion. The clear and convincing evidence showed that Mr. Matachic's use of force was unreasonable and excessive, either or both. In sum, Mr. Matachic's actions were unreasonable and or excessive because victim one did not present herself to be a safety risk, was not resisting, and was not trying to escape. He could have used less intrusive and reasonable alternatives to force, including verbal commands, controlled holds, or escorting her to a patrol vehicle while they discussed their plan of action, how to deal with her. The force used was disproportionate to the circumstances the officer faced. Following the presentation to the board and as documented in the transcripts before you, the board received public comments, including from Ms. Marie Masters, who is counsel for Mr. Matachic, and Mr. Matachic. They provided the following information. They said that there were mitigating factors show that reasonable grounds do not exist to revoke or suspend Mr. Matachic's certificates based on clear and convincing evidence, that he did not have any discipline prior to this incident. Mr. Matachic excelled at the academy based on his performance there. His use of force in this case did not result in injuries. He kicked her to push her away to prevent her running away and falling on her face. Based on Mr. Matachic's prior interactions with victim one, they said that he knew victim one to be violent, previously attempting to escape, and had a history of mental illness, and that his mindset was to use the least forceful hands-on approach by using personal body weapon against victim one. That the IA showed he acted with candor and integrity. In hindsight, they said Mr. Matachic would have handled things differently. Ms. Masters requested that no action be taken against either of Mr. Matachic's certificates. Mr. Matachic himself provided comment that he had had numerous contacts with victim one where she fought him and spit at him and other officers, that he knew her to be violent, a drug and alcohol abuser, and that he gave her 2 commands to sit down. She didn't listen, and his intent was to de-escalate the situation so they could take her to a hospital instead of a jail. Ms. Woolley, counsel for Post, provided comment in response to Ms. Masters' statement. Victim one was seated, and as she's starting to stand up, Mr. Matachic kicked her. This is not a case where he needed to defend himself or others. Training to kick did not include kicking a restrained person. That Mr. Matachic did not accept responsibility for his actions. His thought process was to preemptively attack her, which is not the standard when reviewing reasonableness of force. And in fact, the totality of the circumstances from the officer's perspective showed that the other 2 officers were surprised at the use of force that we did not know if victim one actually suffered injury. Board member Clavo asked clarifying questions about Mr. Matachic's reporting of his use of force to his sergeant, his continued conversation with victim one, and Mr. Matachic's training at the academy regarding kicking. Board member Glazier asked clarifying questions about the proportionality of the force used. Board member Johnson asked questions about the type of force Mr. Matachic used in a previous internal affairs investigation and the ability to use prior conduct in making a decision. The board then went into closed session, and when the board returned from closed session, it voted unanimously to revoke Mr. Matachic's certifications with 6 members of the board present. At this point, I'm happy to answer any questions the commission members may have.
Questions or comments from commissioners? At this point, if no questions from commissioners at this point, if Officer Matachic and his counsel was to speak, please come forward. Introduce yourself for the record, please. Welcome.
Good morning, Marie Masters with RLS Lawyers.
Paul Matachic.
We submitted a public comment, which I assume the commission received and reviewed, but I just wanted to take a few moments to briefly respond to the case presentation. First, there was discussion of the perspective of other officers, and I just want to highlight that that was inherently different than the perspective of my client because his prior knowledge and prior history with the victim in this case was inherently different. He had much more contact with her than either of the other 2 officers on scene. You can see from the video that he was the only one who recognized her by name. So when he said her name, one officer had to repeat it as though it was a question. And it was clear from the footage that he was the only one who actually recognized her immediately. There was also discussion that, he could have used verbal commands. Well, he did. He asked her to sit down twice. And this was all following the need to use a leg sweep to get her to the ground to sit down initially. I believe it was also mentioned that the victim complied with the order to sit down, but that was questioning why, and that's just simply not true. When my client approached the victim to put handcuffs on her, he felt her tense up, and as a result, he needed to use a leg sweep to get her on the ground. So this portrait of her being perfectly compliant is it's simply untrue and misleading. There's also some discussion about the nature of the conversation, that I believe it was categorized. I'm not sure if the word calm was used, but I interpreted the description to be that it was, an unemotional conversation, which meant that the victim was not a threat. And I mean, we all know police officers are taught to be calm. Part of your training in post-certified academies, as well as during FTO, is that you need to remain calm and be able to speak clearly. So this idea that he somehow, because he was speaking in a calm manner, means that there was no threat is also a bit misleading. The other thing I'd like to address is the nature of the way that the kick was described. It seems like the description offered to us earlier was exaggerated. It was enough force to take the victim off of her feet, and that it caused her, you saw the video, it pushed her off balance and she fell backwards, but she didn't, she didn't go flying. She didn't, it wasn't more force than what was absolutely necessary to get her off her feet, off balance, into a position where she could be detained and taken to the patrol vehicle. There's also discussion that it was speculative whether the victim would spit on the officer or any of the officers there, frankly, not just my client. And again, this goes back to his prior knowledge from prior contacts with the victim. She has spat at plenty of other officers at their department. When she was shared earlier, when she was being transported, she spat at the CSO. She actually spat in the CSO's mouth while being transported. And again, it was touched upon in the public comment, and I only brought it up because post requested arbitration materials. So I assume that that's part of the discovery packet now. But the arbitrator was very clear that being spat on is actually a very serious assault. It's not, just something that officers don't like or that they think is gross. It's actually a serious assault. So this idea that, that's somehow something minor that he should have just dealt with is unfair. I'll let my client address it as well, since I believe it'll be more genuine coming from him. But this idea that he was smiling, it seems like that's being used to portray, that he's somehow like pleased with the use of force or something other than what it was. I know he has a few brief words that he'd like to share, and I'll let him explain that to you as well. But that's also just a mischaracterization of what was actually transpiring. It relates to his interpretation of what the conduct was with the other officers. Again, not a reflection of him being pleased with having to have a use of force. So again, just considering the public comment we submitted, all of the evidence that was before you, especially the arbitration materials, we would just really ask that the commission here uses its discretion. And if you believe there is clear and convincing evidence, we certainly do not. But that if you do believe that there is, that you do not move to decertify Officer Matachic. It would honestly set a pretty dangerous precedent that, any sort of use of force, even if there's no injury, that's determined to be unreasonable is enough to have an officer lose their post certificate. At the end of the day, officers will have uses of force that are determined to maybe be excessive or unreasonable, and often the result is a suspension, but they retain their employment. So there seems like it would be a pretty drastic disconnect to have a situation where an officer could keep their job, have maybe a week or a 2-week suspension, maybe even less than that, and then and then be decertified. I'll go ahead and turn it over to my client.
Thank you, Commission, for being here today. I really appreciate you guys listening to everything that we have to say, as well as what's been going on this morning. To decertify me would be a disservice to the Brentwood community, as well as the state of California and policing as a whole. I believe that what I did was justified based on the facts and circumstances, as well as my training that I had received at Brentwood and within the academy. I specifically picked that shift so that I could work better with the homeless community to put them into housing and get them off the streets, and not in a forceful way, in a helpful way. And there are emails with my sergeants and conversations with my supervisors to prove that as well. This specific individual I had multiple contacts with throughout my 4 years, specifically on graveyards working with her. And the other officers that were there with me did not have that same experience. I did not want to have to deal with a individual who I knew was going to fight with us, spit on me, kick me, whatever means that it meant for her to get away while she was in handcuffs in that area. And that's why I took the steps that I did. As far as the smiling, we had a department-wide training on use of force and de-escalation tactics not a month before this incident, where individuals would pretend that they were abusing or physically abusing victims or arrestees, and officers were told to interject. And that's why I turned around and smiled at my coworkers, because I thought they were joking with me based on this training that we had just had. I do not take this lightly. This was not a light situation for me, and I don't laugh or have fun with using force on people. I'd rather not use force on anybody. Instead, had sent Jill the victim to the hospital that day for a mental health crisis. Again, thank you for listening.
If there's any questions for either of us, we're happy to address them.
Ms. Masters, I didn't catch that, your last statement.
Oh, no, if there are any questions for either of us, we're happy to address them.
Questions for council? Seeing none, is there anyone from the public in the audience who would wish to comment on this case?
And Chair Long, I would like to address council's comments, if I may.
Go ahead.
Thank you. So one of the things that council made mention of is that this case would set a dangerous precedent if we did not move to decertify or take any disciplinary action against Officer Matachic. One of the things I do want to remind this commission is that when we're looking at a use of force case, we do have a reasonable officer standard. What they are asking you to do right now is to look at this from not a reasonable officer standard, but to look at it from Officer Matachic standard. That is not the reasonable officer perspective. That's a subjective standard. In this particular instance, we had 3 officers present. 2 of those officers did not think that what occurred was reasonable. They did not think that this victim was a threat to them. They did not think that her act of standing was, as counsel has put it, pre-assaultive behavior. They did not think that she was a danger to them. They did not think that a use of force was necessary. They did not think that the force that was used was reasonable in the circumstances, and they did not think that it was needed. None of them thought that they were in danger at this point. They did not think that she was going to run. They did not think they were going to be assaulted. None of that was occurring. As for the comments about whether or not this victim was perfectly compliant, you can watch the video yourself. No, she wasn't perfectly compliant. It's not uncommon for somebody who's been using substances or maybe have some mental health issues to not be perfectly compliant. But just because a person's not perfectly compliant doesn't mean that they're necessarily going to assault a person. And this was a situation where this particular victim was not necessarily going to assault the officer. The officer thought he was going to be assaulted and preempted that and took an action that went far beyond what the circumstances warranted. And that's what we're asking you to take into consideration here today. With that, I will submit. Thank you.
Commissioner Terrio, Chair, I have a question for the.
Please, Commissioner.
How come you think the other officers didn't do anything? What's your statement on that? Why they were just standing there?
Yeah, so based on 2 things. One, they didn't have the same experience that I did with that specific individual. Officer Flynn, while he had been an officer with the Brentwood Police Department at that time for 9 months, he had been on, he quit the job for a year prior to that and didn't have the contacts with her that I did during those 9 months. Officer Franson as well also didn't have the same contacts with her because he had been working day shift where she's primarily contacted on night shift when I contact her. Also the fact that it was 5:30 in the morning and these guys both had families that keep them up all day, whereas I didn't. They were tired, and it's a Brentwood on a Saturday morning. There's not a whole lot going on, and that's why 3 of us showed up instead of just the normal 2. So I believe that it was a mixture of lack of experience with that specific individual, as well as them being fatigued from early hours in the morning.
Thank you.
Any further questions or comments? Commissioner Woolery.
Woolery, just to confirm, the victim was handcuffed at the time of the what we're talking about?
Yes, sir.
Okay, thank you.
I also know that victim to fight people, including officers, and try and disarm a former police officer of his gun. So I do know her to be a very violent person, even when she is handcuffed.
See no further comment or questions. Oh, Commissioner Nieto.
I'm sorry, because of the comment that you just made, officer. You know that this person would fight officers. You stated that. When she would fight officers, was it while she was handcuffed or would she fight them prior to being handcuffed? I'm a little confused.
Absolutely. So it's both. The reason that I tried to send her to the hospital while she was in handcuffs was to prevent a fight. Contacting her when she's not in handcuffs and she knows she's going to go to jail, she knows that she's going to be arrested, she's going to fight us. She also does the same thing while she's in handcuffs. There was numerous instances of myself and other officers included trying to put her in the back of a police car while she's in handcuffs, and she's kicking at us and she's spitting at us. Mr. Sherborne stated that something along the lines of she had spit at me before, but it didn't directly hit me in the face. That's because I saw her spit at me, and while she's attempting to spit at me, I moved my face away, and that's why it didn't hit me. So to answer your question, she does fight us while in handcuffs and while not in handcuffs. That's why I wanted to send her to the hospital, not to jail, because I didn't want to escalate the situation by telling her that she's going to go to jail, where I know a fight or flight is going to be immediate.
Just to make sure the record's crystal clear, when you say to the hospital, you're meaning for mental health evaluation, is that accurate?
That's correct.
Okay.
Chair Long, if I could just make 2 clarifying comments. Thank you. I think the best evidence in this case is for the commission to watch the videos unredacted, which are available for your viewing. Also, if you'll refer to Mr. Sherburne's ISF, you'll notice that Officers Flynn and Franson were both familiar with this victim as well. Thank you.
Will of the committee, is there a motion?
Commissioner Terrio, I'd like to make a motion to go to closed session.
Session it is. Is everyone back? Let's see, looks like it. Who are we missing? All right, the will of the commission. Is there a motion?
Commissioner Braun,
Motion to
I make a motion to decertify.
decertify. Is there a second? The motion to decertify.
Second Moon.
Mr. Knapp, please call the roll on the motion to decertify.
Commissioner Barcelona,
No.
Commissioner Braun,
Yes.
Commissioner Brazil,
Yes.
Commissioner Cooper,
No.
Commissioner Doring,
No.
Commissioner Yule, Commissioner Gordon,
Yes.
Commissioner Johnson,
No.
Commissioner Long,
Yes.
Commissioner Moon,
Yes.
Commissioner Nieto,
No.
Commissioner Rodriguez,
No.
Commissioner Terrio,
No.
Commissioner Woolry.
Nope.
Motion fails.
Fails. Is there a second motion?
Commissioner Terrio, I'd like to
Sure.
make a motion for suspension of 9 months, basic post recertification training, and no time served on the suspension.
Or second?
Second, Barcelona.
Mr. Knapp, please call the roll.
Yes, sir. Commissioner Barcelona, Commissioner Braun, Commissioner Brazil,
Yes.
Commissioner Cooper,
Yes.
Commissioner Doring,
Yes.
Commissioner Yule, Commissioner Gordon,
Yes.
Commissioner Johnson,
Yes.
Commissioner Long,
Yes.
Commissioner Moon,
Yes.
Commissioner Nieto,
Yes.
Commissioner Rodriguez,
Yes.
Commissioner Terrio,
Yes.
and Commissioner Woolry.
Yes.
Motion passes unanimously.
That marks the end of our casework for today. There, Mr. Executive Director, we've got some future commission dates.
Thank you, Mr. Chair. Yesterday at the commission meeting, we spoke about future dates for future meetings. Just wanted to clarify for March, the March meeting will definitely be in San Diego, at least as of now, not in Los Angeles. In terms of the September meeting, we tried to work around the September 11th schedule. So we have a opportunity for September 8th, which is a Monday, through September 10th. My proposal is that we hold it on the 9th on a Tuesday and the 10th on a Wednesday. We will not have advisory committee during that meeting, so we should be able to do the commission meeting plus any potential hearings. And then second is the December meeting, the November-December meeting, which had a conflict with the PORAC annual conference. And we propose having that Tuesday, December 2nd through Thursday, December 4th. That will allow the advisory committee to meet on Tuesday, December 2nd, and then the commission to meet on Wednesday and Thursday.
Repeat September again.
Yes, sir.
You picked.
Yes. I propose September 9th through the 10th, which is Tuesday and Wednesday. We also have the option for Monday, the 8th, if need be, but just assumed if anybody needed to travel, they could travel on that Monday. Does that work for the commission?
Got something on my calendar for the 4th. I can't think of what it is, so I'll have to take a look at it.
As that was the last item on the agenda, does anyone on the commission have any additional comments before we adjourn?
Rodriguez.
Ms. Rodriguez.
Anyways, this will be my last meeting. I'll resign after I get sworn into office, but I just wanted to thank everybody. I really appreciate working with all of you. And I look forward to coming back and visiting.
Congratulations again,
Thank you.
Assemblywoman-elect. Thank you as always to the Post Brass and staff for their professionalism and superb work product. Is there a motion to adjourn?
Moved.
Is there a second?
Second.
Oh, we've been asked to hold off a moment, so.
my chief. See you later. I have.
So seeing no objection, we are adjourned.